Assalamu alaikum and hello everyone in the new class in the series of lecture which I have already started regarding the international criminal law. Students, today is the ninth lecture and today's topic is the International Court of Justice, and I also would you like to invite your attention towards this very much important topic of the international criminal law. And I would recommend you this lecture, and I hope you will watch this lecture till the end in order to understand the composition, function, and direction and history of the International Court of Justice, as it is the successor of the permanent Court of the International Justice (PCIJ). And here's the today's lecture and slides. Okay, students, international criminal law, and today is the ninth lecture, International Court of Justice. And students, here's the lesson plan regarding the International Court of Justice. In this lecture, we are going to discuss the principal judicial organ of the as it is the principal judicial organ of the United Nations, which is based in The Hague, Netherlands, as all other courts, which are also situated in The Hague, Netherlands. And I'm going to share with you, students, here's the today's lesson plan. In this lesson, I will give you a demonstration or deliver my lecture on the introduction of the ICJ history, composition, and ad hoc judges, president, vice president, and their duties, jurisdiction of the ICJ, and there's a criticism and cases where the ICJ has failed to enforce peace. And thereafter, I will conclude my lecture with the study of the, as usual, with the certain judgment decision of the court with the current cases or past cases. So, students, here is the introduction of the ICJ.
When states disagree on where their border is. When states contest islands or a maritime zone. When one state considers that another has violated a treaty or other rule of international law. And when the UN or one of its agencies needs an opinion on a legal issue, they can turn to the International Court of Justice. The International Court of Justice, or ICJ, has its seat in the Netherlands at the Peace Palace in The Hague. Like the General Assembly and the Security Council, the court is what's known as a principal organ of the United Nations and is the only one not to have its seat in New York. The ICJ is the principal judicial organ of the UN and the world's highest international court. The court has existed since 1946. Its two official languages are English and French. Its founding document, the Statute, is an integral part of the Charter of the United Nations.
Veuillez vous asseoir.
All UN member states, therefore, automatically recognize the existence of the court and can call on its services. The ICJ is the successor of another court, created in 1922 by the League of Nations, the Permanent Court of International Justice. Between 1922 and 1940, the Permanent Court handled around 60 cases. It was dissolved after the Second World War. The ICJ succeeded the Permanent Court on the 18th of April 1946, inheriting not only its statute, but also its jurisprudence and traditions.
En tout honneur et dévouement, en pleine et parfaite impartialité et en toute conscience.
Like its predecessor, the International Court of Justice has two roles. The first is to decide disputes between states. These are known as contentious cases. The Court's second role is to respond to legal questions submitted to it by the General Assembly, the Security Council, and other UN organs or agencies. These cases are known as advisory proceedings. Since the court was established, it's dealt with a large number of cases. The ICJ is not a criminal court. It does not try individuals. Only disputes between states can be submitted to it.
Screens, and here this is the building which is a historical building located in the Hague, Netherlands, and the view of the structure of the court. And I would also recommend you can access the videos regarding the ICJ, and the inaugural video also available on YouTube, and another videos which you can experience directly how ICJ works. So, students, the ICJ, when the international community is the one of the dynamic one, which leads to clashes between the international community is one of the dynamic one, and that things which leads to clashes between the various number of this community. States disagree on where their border is, contest islands of the maritime borders, violate treaties and other rules of international law. Then to who do state turn for help resolving matters of this nature in the job of the which is the job of the International Court of Justice. And the International Court of Justice is not only needed for the resolving international disputes, even the United Nations seeks its help when they need an opinion of the legal question. As the court has existed since 1946, and the official language are English and French, and the United Nations Charter is an integral part of the ICJ. And therefore, all the United Nations members state automatically recognize the authority of the International Court of Justice and can call for its help in any legal matter. So, students, after this brief intro, now the question is here, then what is the International Court of Justice? As in previous lecture we have studied already international court tribunals, ICC, and mixed and hybrid court tribunals, and then what is the need of and what is the role of the ICJ. Then what is the International Court of Justice? As from the International Court of Justice was established under the Chapter 14 of the United Nations Charter, which replaced the Permanent Court of Justice, which exists under the United Nations predecessor, the League of Nations, before World War II. The ICJ is the only major UN body whose headquarters is not in New York City. The court sits in The Hague, Netherlands. The court is the principal judicial organ of the United Nations. And all members of the United Nations are ipso facto parties to the Statute of the International Court of Justice. 15 independent justices elected by the General Assembly and the Security Council. Each serve on the court for 9-year term. In this piece of lecture, which means General Assembly and Security Council will elect independently 15 judges from the member countries, and each judge will serve its tenure, that is the duration of the job of that judge in the ICJ, that is the 9-year term. The primary purpose of the ICJ is to render opinions on the international legal disputes between the states. These cases may only be submitted by the states that have accepted the jurisdiction of the International Court of Justice. Another purpose of the International Court of Justice is to clarify significant international legal questions brought to it by United Nations, General Assembly, and the Security Council. When a United Nations body brings an issue before the court, they are requesting an advisory opinion. The ICJ does not have authority to decide disputes which are involving individuals, the public, or private organizations. Although the court may request that public organization present information in a case. When the states have a case before the court, participants submit written memorials and present oral arguments. When the court is asked to render an advisory opinion, interested or assigned parties also submit memorials and present orally before the court. In both type of cases, interested parties can seek to submit an amicus curiae memorial letter for the friend of the court. Amicus curiae memorial may be submitted by any delegation that seeks to assist the court in defining the issue. These memorials may be submitted by the states not specifically named in the case. As per the Article 38 of the Statute of the ICJ, which is an integral part of the United Nations Charter, establish the source of law to be applied by the court in resolving dispute in accordance with the international law. International convention and treaties, international custom as evidence of the general practice accepted as law, and general principle of law recognized by the civilized states. Since 1945, the court has rendered a number of decisions and advisory opinions. Since the court has no binding enforcement mechanism, not all of the disputing parties have complied with its decisions. Despite this condition, the court's rulings are typically considered as the authoritative interpretation of law and have a strong moral effect on the international legal community. The ICJ has up till now dealt with 177 cases. It does not try individuals, and only dispute between states can be submitted to it. So what we have learned in this lecture, students, that International Court of Justice is the judicial organ of the United Nations, and the Statute of International Court of Justice is the integral part of United Nations Charter, and the article regarding the integrity of the ICJ provided in Article 92 of the Statute, which suggests us that ICJ is not separate component of the United Nations, but all the states who ratified the treaties and convention of the United Nations, or state countries ratified the Charter of the United Nations, are the member of the International Court of Justice. It was the introduction of the International Court of Justice. My next lecture is what is the background and history of the International Court of